Good afternoon, and thank you for joining us today. I am Lydia Morgan, Chief Operations Officer of the Jerusalem Institute of Justice, and I'm happy to be here with you live from Jerusalem. For those who are joining us for the first time, I want to quickly tell you about JIJ's international work. Our international law and public diplomacy department operates both in the international legal arena as well as in the public diplomacy arena in order to best represent Israel's interests on all platforms. Our department strives to uphold human rights in the Middle East and safeguard the legitimate standing of the State of Israel among the nations. Today's session will cover the recent dramatic announcement of Chief Prosecutor Fatou Bensouda of the International Criminal Court, or ICC, regarding the initiation of an official investigation of Israelis for war crimes. This investigation covers retroactively the time from June 13th, 2014 to the present, and the areas comprising the Gaza Strip and the West Bank, including East Jerusalem. The decision published on March 3rd marked an Israeli legal and diplomatic loss and presented a significant Palestinian achievement. Today, I want to share with you the history behind this decision that begins 10 years ago with a scandalous and biased chain of events that could end in arrest warrants for Israeli citizens being issued. We will also explain the potential ramifications of such an investigation. We will then touch upon Israel's main dilemma, whether to cooperate with the ICC or simply boycott it. Our session will conclude with an analysis of Israel's limited arsenal of tools to fend off this threat. Special attention will be given to the American involvement. Before we continue, I would like to clarify that my use of the word Palestine, to avoid misunderstandings, I use it in the same way it is applied by the ICC. Our story begins in September 2011 when Mahmoud Abbas, the chairman of the Palestinian Authority, asked the Secretary General of the United Nations to recognize Palestine as a member state. This state, according to Abbas, should include all the Palestinian territories occupied by Israel in 1967. This move was a clear breach of international law as it violated the 1995 Israeli-Palestinian Interim Agreement that states that the parties are not allowed to initiate actions that would change the status of the disputed territories prior to a permanent arrangement. 1 year later, in November 2012, the United Nations General Assembly, in fact, did accept the Palestinian request and upgraded the status of Palestine to a non-member observer state. As a side note, I'd like to point out that according to the UN Charter, membership at the UN is open to all peace-loving states. And I am baffled as to how that aligns with the ongoing Palestinian terror against Israel through jihad, martyrdom, and pay-for-slay practices. Equipped with its new status at the UN, on January 1st, 2015, the Palestinian Authority requested to join the ICC as a member state with the intention of bringing criminal charges against Israelis, as I said, retroactively from the date of June 13th, 2014. Now, I want you to grasp the significance of this date, as the 13th is not just a random day. 1 day prior, on June 12th, in a horrific terror attack, 3 innocent Israeli teenagers were kidnapped and murdered by the terror organization Hamas. This terror attack forced Israel to retaliate and led to the Protective Edge operation. Nevertheless, in order to appease the Palestinians, the ICC agreed to exclude the date of the horrific murders and start the investigation on June 13th. Only 2 weeks later, on January 16th, 2015, the prosecutor accepted Palestine's request to join the ICC as a member state and announced the opening of a preliminary examination into the situation in Palestine. Accepting Palestine's request was legally flawed, as it recognized Palestine as a state, even though the state of Palestine does not meet the conditions for statehood, as we covered in a previous seminar. The ICC at this time officially opened the door for the Palestinians, offering them a new platform to act against Israel. This was another diplomatic win for the Palestinians. A designated Palestinian team at this time was placed in the very halls of The Hague, close to the court's offices, in order to harass and keep pressure on the office of the prosecutor of the ICC. Anti-Semitic nonprofit organizations, unfortunately including some Israeli ones, were responsible for providing the ICC with false materials against Israel. This coordinated campaign bore fruit, and on Friday, December 20th, 2019, after 5 years of preliminary examination, the chief prosecutor of the ICC expressed her determination to investigate Israelis for war crimes. This investigation should include, according to the prosecutor, 3 potential charges. 1, excessive use of force during the 2014 Protective Edge operation on at least 3 occasions. 2, the transfer of civilian populations to occupied territories after 2014 and the expansion of Israeli settlements in the West Bank and in East Jerusalem. 3, crimes allegedly committed by IDF soldiers during the quote-unquote peaceful March of Return that started at the beginning of 2018 along the Gaza border. In response, Israel strongly rejected the prosecutor's decision and raised its own firm arguments. Israel's position is that the ICC lacks any jurisdiction on this matter, given that no sovereign Palestinian state exists, and therefore it has no authority to refer matters to the ICC. Israel's position, by the way, is getting extensive support from key states such as the United States, England, and Germany, and from many prominent legal experts. Chief Prosecutor Bensouda was well aware of the controversy surrounding this step. She knew her decision would provoke severe reactions from Israel. Therefore, in order to share the weight of this political hot potato, she asked the judges of the court to rule on the scope of the court's territorial jurisdiction. 2 of the 3 judges provided the chief prosecutor with the support she needed, so desperately needed, in an absolutely outrageous ruling published on the 5th of February, 2021. It was decided that the court may indeed exercise its criminal jurisdiction on the situation in Palestine, and that the territorial scope of this jurisdiction extends to Gaza and the West Bank, including East Jerusalem. Judge Peter Kovacs, the presiding judge, appended a partly dissenting opinion in which he provided a strict criticism, expressing his displeasure with the ruling. Judge Kovacs disagrees with the ruling based on the fact that Palestine doesn't qualify as a state. And I quote, "All the indications show that it is premature to speak of a full-fledged state." In a document over 160 pages long, Judge Kovac points to a substantial failure in the majority's ruling. I find neither the majority's approach nor its reasoning appropriate in answering the question before this chamber. And in my view, they have no legal basis in the Rome Statute, and even less so in public international law. He further added, acrobatics with provisions of the statute cannot mask legal reality. Now, what can we expect? We understand what led to this threat to Israel. Let's take a look at what is expected to happen next. According to ICC protocols, Chief Prosecutor Bensouda must issue an official letter to the Israeli government in order to formally notify it regarding the court's intention to launch an investigation. The ICC must inquire whether Israel is interested in carrying out the investigation itself. Israel would then have 30 days to answer the letter and inform the court of its intentions. Israel's response to that letter is critical, since it will determine whether it acknowledges the court's jurisdiction and also the extent of cooperation that Israel will give the investigation. Israel's main concern is the issuance of international arrest warrants against Israelis. The problem is that these orders are usually issued secretly, and once an arrest warrant has been issued, every member of the ICC, there are 122 by the way, every member state, all 122 of them, are obligated to enforce the warrant and arrest the suspect. The ICC is targeting mainly senior members of the military, security, and political echelons. But senior officials who are involved in the promotion of settlements are also expected to be investigated. The ICC threatens the Prime Minister, the IDF Chief of Staff, the heads of Judea and Samaria, and generals in the IDF. Israel, in preparation, has compiled a list of more than 200 senior officials who could possibly be arrested. Israel will ask them to refrain from flying abroad until further notice, even though such an investigation is expected to take several years. Think about that for a moment. Imagine you have served your country as a general in the IDF for many years, and suddenly you can't travel to any of 122 countries for fear of arrest. With its back against the wall, Israel must decide whether and to what extent it wants to cooperate with the court. So far, Israel's response has been unclear. On the one hand, it has argued publicly that it does not recognize the ICC. And on the other hand, it sent official and unofficial delegations to meet with ICC representatives. There is no doubt that Israel faces a major dilemma. Past experience teaches us that when Israel chose not to cooperate with the International Court of Justice, it was severely criticized. Israel paid a heavy price for its refusal to collaborate with the ICJ, the International Court of Justice, in its 2004 legal opinion on the legality of the security fence. On the other hand, the entire success of the ICC's investigation very much depends on Israel's cooperation. Chief Prosecutor Bensouda in her statement said, "In carrying out our work, we count on the support and cooperation of the parties." Israel should listen very carefully to that statement, as there is a message between the lines. What Bensouda is actually saying is that a lack of cooperation with the investigation may prevent its success. The ICC investigation poses a new kind of threat to Israel. And as the process moves forward, the arsenal of tools available to Israel is limited. Israel is currently examining whether it correctly assessed the ICC's threat and its consequences, and whether this challenge has been properly handled. At this point, Israel must come up with an effective and powerful strategic plan. It must use every means available. Such a plan should prioritize the adoption of the diplomatic safety net offered by the United States only a few months ago, if indeed that is still available. There is no doubt that Israel's capacity to ward off this new threat is very much dependent upon American support. But like Israel, Biden's new administration understands the importance of American backing for Israel, as does the ICC. That is why both the judges and the chief prosecutor waited with the publication of their decisions until Biden's new administration entered office. They knew that the response of the Trump administration would have been much more aggressive and potentially led to further escalation. I'd like to remind you that it was Trump's government that authorized economic and travel sanctions against employees of the ICC and anyone supporting its work due to an investigation into war crimes of American soldiers in Afghanistan. The new US State Department has already announced its intention to reconsider the sanctions imposed by Trump's administration. We may even cooperate with the ICC in exceptional cases, it added. In a press statement by Biden's US Secretary of State, Antony J. Blinken, the US expressed its displeasure of the ICC expected investigation of Israel. The US firmly opposes and is deeply disappointed by this decision, said Blinken. The Palestinians do not qualify as a sovereign state and therefore are not qualified to obtain membership as a state in, participate as a state in, or delegate jurisdiction to the ICC. He added, we will continue to uphold our strong commitment to Israel and its security, including by opposing actions that seek to target Israel unfairly. Changes in the American approach towards the ICC and what was not said in the press release may be more important and may directly affect Israel. Israel desired a far more militant response from the US, including threats of sanctions. And it hoped the US would provide it with a more obvious protective shield. There are some leaders in Israel that say Blinken's response was soft and signaled to Israel that it may not find the support it needs from the US. It seems that halting the opening of the investigation will be almost impossible at this point, but Israel must not give up and must put up a fight. Israel has proven many times before that it is capable of finding out-of-the-box solutions in difficult circumstances. Since any attempt to fend off political interests with legal arguments is doomed to fail, Israel must focus on the following steps. It must apply heavy pressure on the court, delegitimizing its authority over the jurisdiction to investigate Israel on every platform available. When the court is biased against the state of Israel, there is only one thing that can be done: to fight for the truth in all countries, on all stages, and in all forums, said Prime Minister Netanyahu. Israel needs to gather wider international support, calling on heads of states and governments to join Israel in the protection of the international legal system from political partisanship. We must ask them to refuse to cooperate with the ICC and to reject its decision concerning Israel. We may also ask heads of states and governments to cut their funding to the ICC. And Israel must promote an agreement with as many countries as possible Do not extradite Israelis for whom the court has issued arrest warrants. Additionally, Israel needs to apply pressure on the newly elected chief prosecutor Karim Khan, demanding that he reverse Bensouda's determination to investigate Israel. Newly elected prosecutor Khan was Israel's preferred candidate, and leading opinion in Israel is that Khan will not cancel the entire procedure, but will not feel obligated to advance it either. Israel expects that prosecutor Khan will accept its main argument that the ICC lacks jurisdiction to proceed with the investigation. There is also the potential that Israel will promote legal actions and prohibit Israelis from cooperating with the investigation, a criminal ban on providing information and assistance to the ICC. Similar legislation exists in the US since 2002. It is called the American Service Members Protection Act and is a federal law that protects US military personnel and appointed officials of the government against criminal prosecution by the ICC. This is legislation, incidentally, that President Biden supported during his time as a senator. Israel also needs to promote a legal defense based on the principle of complementarity, convincing the ICC that Israel holds a self-reliant, independent, and impartial judicial system that conducts all the investigations and inquiries needed. Therefore, the ICC's interference is not required, nor is it welcomed. In conclusion, the ICC in its ruling grossly trampled any legal and moral principle on which it rests. It succumbed to political pressure and overstepped its authority. The court set boundaries for a state that does not exist, and it intervened in the Israeli-Palestinian conflict contrary to an explicit agreement between the parties. This ruling clearly illustrates how the court deviates from the mandate given to it and from the purpose for which it was established. I want you to remember three important things from today's session. 1, the International Criminal Court's ruling to investigate Israelis for war crimes is political and not legal. 2, the International Criminal Court lacks any jurisdiction over the so-called situation in Palestine. And 3, the ICC's interference is not required, nor is it welcome, since Israel holds a self-reliant, independent, and impartial judicial system. We have covered a lot of material, and we've come to the end of our time together today. I want to thank you for joining me. I look forward to receiving your questions and comments. Please email them to the email provided. And on behalf of the JAJ team, blessings and shalom from Jerusalem.